So very good morning everyone. Hello, good morning everyone. So in the previous session we completed maximum portion of the chapter number 2, Incorporation and Incidental Matters, but still pending in the last part with regard to the concept regarding incorporation of companies. Related concepts have been completed. The only thing that was left for consideration is last miscellaneous 3 topics are there. I think we didn't complete subsidiary to hold the shares in its holding company. So that we have to complete section number 19. Later we need to complete 20, 21 and 22. With that, entire chapter with regard to the incorporation and incidental matters will get completed. We then will come into the next area called as second chapter, prospectus and share capital. Actually those are 2 chapters. We merge both of them. Both will come for 25 marks in exam. Put together. Prospectus and share capital. Both put together will come for 20 to 21 to 25 marks in exam in general. So before we start with those, please, before we start with the chapters, let us first complete this area full-fledged. Bayrakla we need to come to section number 19. Bayrak come to section number 19. This was asked 3 times in exam already. Easy only, but first we need to have a clarity once. See here. Shall we start everyone? First, you can see the section in the Bayer Act. So see the provision once. What is the name? Subsidiary company not to hold the shares in its holding company. So who should not hold? Subsidiary company should not hold the shares in the holding company. Sorry. I will first explain you the concept. Later you can read. See here. Everyone in the class know what is a holding, what is a subsidiary company already. Holding company means holding company in relation to another company means a company in which such one or more other companies are its subsidiaries. Subsidiary company in relation to any other company means a company in which that any other company, namely the holding company, okay, first it can either control the composition of board of directors or exercises or controls more than 1/2 of the total voting power either at its own or through one or more of its subsidiaries. So this is the thing that we consider there. Okay. So either you become a holding subsidiary, either board control should be there or shareholders control should be there. Any of these 2 must be controlled in order to become a holding subsidiary. Everyone listening? We are now going to understand what is the intention of this particular section. What do you mean by holding company not to hold the shares in, subsidiary company not to hold the shares in holding company? See there are 2 companies. X Limited and Y Limited. X Limited on 30th December 22 acquired 60% of the capital of Y Limited. 60% of capital of Y Limited. Therefore, X become which company? Holding company. And Y will become which company? Up to here understandable. One become holding and the become subsidiary. Now the problem is, like this it happened. On 30th Jan 2023, Y Limited started holding 52% in X Limited. Now automatically who will become the holding? Y Limited will become the holding. That is impossible. Like this it cannot be. This hybrid relation can't exist. That means first who became holding and subsidiary, we need to check it. Okay? Tell me, first who became the holding? If this is possible, you can't create a possible relation between two companies. Who is holding, who is subsidiary means confusion always. You held 52 in me, I held 52, okay. So you held 60 in me, I held 52 in you, automatically I am subsidiary, you are also a subsidiary to me. So that possibility should not be there. Either only one should be holding, another should be subsidiary. One parent company, one child company should be there. Clear everyone? So therefore try to understand it clearly. The point is, whenever there are two companies, X Limited and Y Limited, one company already acquired the shares of another company and making it subsidiary, the subsidiary cannot again hold the shares in the company called as its holding company. Repetition one last time. One company acquired substantial shares in another company, making it its subsidiary company. Means that company is holding, this company is a subsidiary. Once after getting the status of a subsidiary, you cannot again hold the shares in its holding company. It is strictly prohibited. Once you become subsidiary, you cannot hold the shares of your holding company. Clear everyone? Yes, question arises. That means once Y Limited became a subsidiary of X Limited, can Y Limited purchase the shares in X Limited? Can Y Limited purchase the shares in X Limited? Answer: impossible. It cannot. In any way it is not possible. Clear? Sir, through stock market it will buy, sir. In the records of the depository, you will be blacklisted to buy the shares of that company. Who will be blacklisted? Y Limited will be blacklisted in the records of the depository to buy the shares of whom? Therefore, question of buying through stock market closed. There is a prohibition on X Limited to allot the shares to Y Limited. If X Limited goes for public offer, Y Limited cannot subscribe to the shares. Who cannot subscribe? Y Limited cannot subscribe. In third case, whenever X Limited is not allotting the shares, I am purchasing from another person through transfer of shares, not in stock market. Physical shares are transferred. In that case, you can't transfer the shares also. Simply to understand, complete prohibition on which company? In our example, that means Y Limited can acquire, cannot acquire? Cannot acquire the shares of after becoming its question number last. Is there any exception to this? Is a question. 3 exceptions are there. How many? 3. 3 exceptions are there. Listen carefully. What are the 3 exceptions? Exception number 1. Subsidiary company is holding the shares in its holding company even before it became a subsidiary. Clear everyone? That means X Limited is holding the shares of Y Limited from which date onwards? Some people are not in this world, for your health sake, please. Okay? Start again. Who is holding? In which company? How much holding? That means what is the date of becoming holding subsidiary? 30/12/2022 they became holding and subsidiary companies X and Y. Now listen to the point. Y Limited is holding shares in X Limited worth 22%. How much percent? 22% it is holding from 31/20/21 itself. Now tell me, this is a pre-holding or post-acquisition holding? That means even before you became my holding company, I am holding the shares in you. Clear everyone? That means that acquisition is made after becoming a subsidiary or before becoming a subsidiary? Before. That means subsidiary relation is not there. Clear or not everyone? How much it is holding? 22. The X will become subsidiary, Y will become holding? No. Up to here understood everyone? But there is one very important point. On this 22% voting share of Y Limited on X Limited, voting rights will not be given, or else you control holding company. Parent should control child, child should never control parent. Basic common sense throughout the world. Are you understanding the point or not? Even 1% also you should not do. That's the intent of law. Lawmaker want to tell that once it became a parent, as a child never say no to that. So the lawmaker's intention is absolutely clear to say that if holding company want to control you, you should get control. You can never control holding company. But exception is, whenever the holding company X Limited gives a dividend, Y Limited will receive the dividend. But you don't have which rights? Voting rights will not be given. Everyone understood the point or not? So now summarize everything and tell me, who is holding the shares? Is holding the shares in? It became? X Limited became? Y Limited became? Once becoming subsidiary, after acquisition and after becoming holding subsidiary, can X Limited, Y Limited hold the shares in X Limited? Can X Limited allot to Y? Can Y Limited acquire from the market? Nothing is possible. No way possible. All the doors are closed. Right? 1 point over. Everyone. How many exceptions are there? 3. Exception number 1. I will give exception to that percentage of holding which was acquired by. Don't tell Y Limited, yeah, acquired by. Even before it became a subsidiary. Number 1. However, in that case, the percentage of holding whatever you have, on that will you get voting? No voting? Next point also over. After that, the next point. In next 2 exceptions are there. Number 1, legal representative of deceased member of holding company held as a trustee for the holding company shareholders. Sir, I didn't understand this too. Sir, I will explain the point clearly. Listen. There are 2 concepts. One is called as a transfer. Another one is called as a transmission. 2 types are there in Companies Act. Listen carefully. Transfer, transmission. Transmission means automatically it comes from one person to another person. Like virus. Virus get transmitted. It will not be transferred. Transfer require permission. Transmission don't require your permission. Automatically it will come. Clear everyone? You will give permission to COVID virus. That means, okay, today I am granting you permission on a stamp paper. Now come, join me. It's a transmission, automation. Sir, okay. If 2 persons are there, listening everyone? If 2 persons are there, X and Y. X will sell the share, Y will buy the share. Both will enter into agreement to take a stamp paper, sign the documents, everything done, consideration paid, shares transfer from one person to another person. This is transfer. X is there, shareholder of TCS, X died. Immediately shares will get transmitted to his son. Son here represents a legal representative. Everyone understood or not? Yes, listen now. There is a person called as Mr. A. Mr. A is a person, individual. Mr. I am using. Mr. A. is a shareholder of TCS, that person is holding the shares of TCS. Clear everyone? Now listen, I will give you example. X Limited, Y Limited. X Limited held 60% in Y. X Limited is a, Y Limited is a. One of the shareholder of X Limited is Mr. A. He is a shareholder of Y, shareholder of X. Now listen carefully. This Mr. A kept Y Limited as legal representative. Kept Y Limited as legal representative. Anyone can be legal representative. You need not be individual. Children are not there. What they will do? Children are not there to some persons, and who will be the legal representative? Some entities or some persons will be there. Am I clear? So therefore they kept legal representative as whom? Y Limited. Now everyone understood the point? Yes, tell me. Mr. A died. What will happen? Shares of X Limited will be transmitted to the hands of everyone. Now tell me, Y Limited is what? Subsidiary or holding? Now subsidiary is holding the shares of holding company. But it is holding in its own capacity as a representative capacity. That is permitted. Everyone understood? Voting right will be given or will not be given? Will be given in that representative capacity, because I am not voting as Y, I am voting as Mr. A. Will be given. In the first case, I am directly holding it. Now understood the point, everyone? 1 point over. Sorry, listen carefully. Why Avesam? Avesam, why you give answers always? Every time wrong answer. Not even one time correct answer. What? I didn't understand. What? Mr. A. He is the holding? He is holding. Who is holding A? At that time they will not keep one legal representative. They will divide that. Now see here. Please see here. As per your question, if Mr. A is holding 60, how can it become subsidiary to another company? Yes, sir. That's what I am asking. Then it will not hold shares in any other company, because already it itself is controlled by only one person. Sorry, okay. Listen carefully. First, legal representative example, everyone understood properly? Now, third example. There is a company called as X Limited. There is a company called as Y Limited. Same example, X Limited acquired 60% capital of Y Limited. Now what happened is, shall we continue? Listen carefully. X Limited, Y Limited, how much is the capital held? 60% is the capital held. Sorry. Now listen. In this X Limited, Mr. B is a shareholder holding 10% shareholding. How much percent? 10% shareholding. What happened? Let us see. B is a author. B is a author. Somewhere you might have heard. Tell me, what is a trust? Trust in obligation. Obligation to do what? Obligation to provide benefits. Provide benefits to whom? Specified persons called as. Who will create a trust? Cast obligation on whom? Trustee will be the discharger of obligation. Clear? So trust in obligation to provide the benefits, providing benefits to specified persons. These specified persons are called as beneficiaries. Who will create the trust? Cast obligation on. Trustee will become the Author will not directly give instructions. He will transfer the properties in the name of trustee. Who will transfer? Will transfer what? Properties. To whom? Those properties are called as property held under trust. These properties are shares of X Limited and this trustee is Y Limited. In this case, who is holding the shares? Everyone, one small thing for you. I request, I forgot to tell actually. I'm very sorry, I forgot to tell. Good morning. Good morning, everyone. Good morning, everyone. Very good morning, everyone. Listen. Listen. So, tell me, what are the two companies involved? X Limited and? Who is holding? How much? Of which company? Next, in that X Limited, who is holding 10% shares? Answer here. That Mr. B is a author also. He created a trust. I did it. So, no claps. To book. So therefore, trust means an obligation to provide some benefits. Sorry, okay, come back. Main point is, B is a author, created a trust. Okay, to the trust, B is the author. Now, author will cast obligation on whom? The trustees. Who is the trustee for author? Y Limited. Obviously, the other day I discussed about trust concept. The day I discussed just because of very much a good reason, because once I discussed that, repeatedly again and again the word trust I need not define every time it comes. It will come in debenture trust deed, income tax trust concept is there. At that time doubts will not come again. What is a trust? Sir, okay. Mainly let us come to the point. In this particular case, one of the shareholders' shares are transferred to our company being Y Limited in its own capacity, in capacity as a trustee. It is holding in its own capacity or representative capacity. It is also permitted. I told you 3 exceptions now. First, tell me the general rule. What is the general rule? Subsidiary company shall not hold the shares in its holding company. Not only just to hold, that company should not allot to me. I should not get the shares acquired. Everything is prohibited. How many exceptions are given? Everyone tell me, what is the first exception? Holding is made by the subsidiary even before it became a subsidiary company. Number 1. Number 2, 3. Subsidiary is holding the shares in which capacity? Legal representative of deceased member of holding company. Third one, holding in capacity as a trustee to the shareholder of holding company. This is what section 19 want to convey. Everyone understood the point clearly? You read now, just 1 minute we will complete this. Please read section 19. No company shall, please read, no company shall either by itself or through its nominees hold any shares in its holding company, and no holding company shall allot or transfer its shares to any subsidiary company, and any such allotment of transfer of shares to a company to its subsidiary shall be void. Everything we already read or not? Yes, new point you are learning is the impact. If you do, what will happen? Void. 1 point over. You should not acquire, they should not transfer, they should not allot. Over. So, subsidiary cannot hold the shares in holding. Done. Provided that nothing in this subsection shall apply to a case. How many are there? A, B, C. Means how many points are there? Okay. Read. Where subsidiary holds such shares as legal representative of deceased member of holding company. Exactly, I said the same or not? Next, continue. Where subsidiary holds such shares as a trustee. I can give more clarity. If I were to write the Bare Act, I would have written it in a more clear way. So trustee to whom? Sir, if I tell like this, where subsidiary holds such shares as a trustee. In class, I explained you the entire background, trustee, author, what to do, property, transfer, income derived from property. I told you, you can understand whenever the word trustee comes, immediately you can understand, this is the meaning. But normal person, how can he understand? Therefore, you can be more clear when you are writing the Bare Act. Sir, okay, the point what I want to tell is, trustee is a loose word. Trustee to whom? Trustee to the member of the holding company. To him the company is acting as a trustee. Sir, okay, next, where subsidiary company is a shareholder even before it became subsidiary company of holding company. Had I told you this point already or not? Exactly, all the three exceptions are over. Okay, now, one point, tell me, voting rights will be given or will not be given? Use your common sense. First case like will be or will not be? Yes or no? Second case? Third case? Read the proviso. Provided further that the subsidiary company referred to in preceding proviso shall have a right to vote at the meeting of holding company only in respect of shares held by it as a legal representative or as a trustee. Means, what does it mean? There is a rule of interpretation called as expresso unius est exclusio alteris. 9 rules are there, not espresso coffee. Totally how many rules are there? 9. 9 rules. Rule of literal construction, reasonable construction, harmonious construction, beneficial construction, exceptional construction, legistum generis. Nascit res is contemporary expositio, expressio unius est exclusio alteris. How many are there totally? 9. In that last one, what it says is expresso unius est exclusio alteris. Means if there is say some words that are used, so many things are there, in that if I include one, automatically it will exclude other. Example, 2 persons are there. Your name? Ram Kumar. Okay, your name? Bharata. Okay. Chandua. Chatura. 3 idiots to Chatura. Audit? Oh. Then who is virus? Sir, listen. Sir, see here. Sir, leave. Don't tease him. Listen. 2 persons are there. Hey, listen here. 2 persons are there. Ram Prasad and your real name? Ram Prasad, Ram Kumara. Ram Kumar, sorry. Ram Kumar, your original name? Bharat. Okay. So, sir, R and B. 2 persons are there. Ram Kumar and Bharat. 2 persons are there. Now I said, Bharat is a very good person. And I said away. Listen. Please, at least in example let him make good. At least in examples let him make. So listen. Ram Kumar and Bharat are there. To some person, to a third party I am telling. 2 persons are there. These 2 persons are very well known to me. Bharat is a very good person. And I went away. What does it mean? Ram Kumar is that meaning will come or not? When 2 things are there, I am qualifying a good thing or a bad thing only to one of them. Automatically other will become reverse to that. That means expresso unius est exclusio alteris means expressly if you exclude certain things, remaining will automatically get included. Or if you include something, automatically it will exclude the others. Same thing even here. A and B clauses, you will have voting right if he is telling. What does it mean? In the C clause, you don't have a right of vote. That's a rule of interpretation. Everyone understood, huh? So many situations like direct taxes also plant and machinery, that concept came in Supreme Court case laws. Plant and machinery, what is a plant, what is a machinery, doubt has come. Are you understand or not? Sir, if you deep groundedly read income tax, in Companies Act, all these things, so many rules of interpretation court will use, especially in any of these 9 rules. In that plant and machinery time, so many cases happened. What is plant, what is machinery? Are you understanding or not, everyone? So they got a doubt. Plant and machinery is a mobile property or immobile property? Plant and machinery is a mobile or immobile? Plant is immobile, machinery is mobile. Game over. This is what Supreme Court has said in Ramaswamy Sons and Co. Chennai High Court, Honorable Madras High Court has given a judgment. So plant is something. That's why it's called as a plant. It is grounded to the earth. You can't move it. That's why the word plant has come. Machinery means which can be mobile. So both, one is a plant, another one is a machinery. This is what they said in section number 32(1). So 32(1), in that particular case law, they define this particular term. Like this, try to understand, please. Plant is defined by the court, Supreme Court. Supreme Court defined plant as something which is grounded to earth, which cannot be used unless it is grounded. Unearthing of that particular plant is unusable. This is what the Supreme Court judge has said in that section number 32(1), read with the Ramaswamy and Co. Honorable Madras High Court has given a judgment. So this is what they said. For example, do you know the flour mills? Flour mills. Flour mills. How they work? Big circles type of, ribbons will be there. Cloth ribbons. Now you see, when the flour mills are working, they will be grounded to the earth. Hope you can understand. Even after grounding them with the nuts and bolts to the earth, there will be a shaky movement of that. But they maximum try to make it earthen to the ground, they will do it. Those are plant, not machinery. Those comes under the category of plant. Construction business, clinker machines will be there. Wherever they want, they can take it. Mixing machine will be there. Stone, cement, clinkers, all mixing will be there. Round. It will roll. The drum will roll. Those are machineries as per the rules of income tax. Those are not plant. Hope you can understand that. Plant is defined by law. Therefore, machinery I need not define separately again. Whichever is not grounded to earth, by applying the rule of expressio unius est exclusio alteris, anything other than grounded to earth, we call it as a machinery. Like that, the rules of interpretation will work. Sir, anyway, everyone understood the concept clearly, yeah? So tell me, under which cases you will get voting rights? Don't tell A and B. Tell me which cases. When you are holding the shares as a legal representative of deceased member of holding company, when you don't get the voting rights. If you are not holding it as a legal representative, if you are not holding it as a trustee, then you will not get the voting rights. Simply the pre-holding of the subsidiary in the holding company. Everyone understood the point? Huh? That's all. Section 19 completed. 2 minutes time I will give you. Read section 19. Once you complete, we go to the last set of sections 20, 21 and 22. With that, the chapter will be completed. I didn't understand. If company holds, one company has 2 subsidiaries. One second. X Limited has 2 subsidiaries. Huh? One subsidiary, Y Limited. Arey, just now you said X Limited has 1 subsidiary. You are only telling X Limited has 2 subsidiaries. You frame the question, huh? Okay. Continue. Continue framing question. Huh? Why hold? You cannot hold. Convertible just is an equity. No, you cannot. You cannot. Then holding subsidy relation they don't create. If that be the case, they don't create it. Can the subsidiary of subsidiary company? No, anyway it is also a subsidiary. Subsidiary to my subsidiary shall be deemed as a subsidiary. Anyway subsidiary provision will apply. Yes. First they don't even acquire the equity. For example, as you said, if you hold convertible debentures of X Limited. Okay, who hold Y Limited you are talking? Convertible debentures. That means X issued convertible debentures to Y. Y subscribed them. So it will become equity shareholder after acquisition. That's what you are telling. What I am telling is after conversion only they will acquire by and they become holding company. During that they will not. Guidelines will not permit them to do so. First convert them, become equity. After that only X will acquire in Y. Then that will become pre-holding of Y in X. Yes. Framed. Now tell the framing. 1 second. Okay. Hey, I could not hear here. Please listen. A has X and Y two subsidiaries. Okay, done. One more company. No, don't do that. Right here. You come here. Happily you write. Who stopped you? Erase this. Erase this. Right. S Limited. Who is subsidiary? X and Y. Subsidiary to S. Subsidiary to S. Okay. 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 Done.
Sir, these both are not holding of this.
Yes.
This A Limited can hold.
Yes, obviously.
That is only, sir. I'm asking. No, not that. You told me subsidiary cannot be like.
This is not a subsidiary, na?
We can't hold like holding. Subsidiary company cannot hold in a holding company, right? You told.
Yes.
So this can hold in this both, right?
Yes.
That is what I'm asking because anyways this holding company makes.
Anyway, this is not holding to A. Because if S is also holding some percentage, then only A becomes a subsidiary to S. Because through its subsidiaries also it can hold. In this case, no, it is not a holding. It can hold. That's what. Then thank you. You also have some doubt, Ram Kumar? ఏం లేదా డౌట్ ఉందా? అరే 1 second. Let him ask the question. Yes. Associate you can. Next one. So we now completed section number 19. Next one. Come to section number 20. Everyone please come out to section number 20. Service of documents. Section number 20. So what is this concept of service of document? And moreover, section number 20, 21 and 22. Most left out concepts of this chapter. You generally test other than me. I teach every single section, important, unimportant, exam, not in exam, everything I give important, but still, hey, listen here. So the point is, most left out concept means student will not feel pleasure of reading last topics of any topic. Because with what sort of zeal you start at the beginning may not be there at the end. They will ask only end questions in exam. So therefore, please ensure that last 3 sections are more important than any other section in any provisions. Take share capital, take debentures, take general meetings. Last topics are very important for exam. Like this. Just because of the reason that so we are now going to read, please, we are now going to read the concept called as service of documents. So 3 sections are there totally. Section number 20, 21 as well as section number 22. All the 3 sections are having a common intention. Miscellaneous provisions, please. So all the 3 are miscellaneous provisions to incorporation chapter. As I said, if you remember, at the beginning, initial days of the classes, when we came to know about the basics of how to read the law, there I said about a concept called as a chapter to you. What is a chapter? I said, all the concepts which are commonly related to one common situation will come under one set of sections called as chapters. Sorry, I will explain this way. Dividends, all sort of concepts relating to dividends will go to chapter 8. Books of accounts, accounts of company, chapter 9. Audit, auditors, chapter number 10. Like that, any common thing belonging to a common set of understanding will be made as a chapter. Clear, everyone? Yes, sir, in what way these 3 sections are relevant to incorporation is a question. First, one should get that question. Service of documents, authentication of documents, proceedings and contracts, execution of bills of exchange, how this is related to incorporation chapter is a question. Everyone understood what I asked? Nah? In what way you can correlate this with the concept of incorporation? Listen carefully what the 3 topics are talking about. See here. Whenever a company is incorporated, company will get its own office or company will get its own address. We call it as a registered office. We call it as a everyone we call it as a directors are there in the company. I don't want to communicate to the company only. I want to communicate. ROC want to communicate something to the company as well as directors of the company. In that case, at the time of incorporation itself, we should make the details of registered office and addresses of the directors clear such that whenever department want to serve any kind of document on the company and the directors, to whom I should send it, to what address I should send it, must be there from the date of incorporation itself. Simply to tell details of the directors, their addresses, every single detail must be available with MCA from the date of incorporation. Repetition one more time. The details of the registered office of the company, the details of the addresses of the directors of the company must be available with the MCA during the course of incorporation itself. Anyway, you will file the verification of registered office. You didn't remember. Verification of registered office will be made within how many days, sir? Anyway, you will file. But before the 30 days, what will be there? Address for correspondence. I told you temporary address will be there. That means either this or this, some address will be there or not. Directors anyway will have some address. All the details must be made available from the incorporation date itself. Everyone understood the point or not? Therefore, that topic came in, service of documents came in incorporation chapter. That means these are the things which you need to make available from the incorporation date. That's why what is the name of this chapter? Not incorporation, incorporation and incidental matters. These are all incidental to incorporation. Understood the point, everyone? Next issue after this. Authentication of documents, proceedings and contracts. Next one, execution of bills of exchange. Meanings we will discuss when we come to those sections. First, let us complete section number 20. Please see the screen, everyone. Mark 20, 21, 22 as the most important in the chapter. If really I have to prepare a question paper, I will not ask any of the previous. 2 questions I will ask from 20, 21 and 22. That's all. If you prepare, you will pass, or else come again. So what are the 3 sections? 20, 21 and 22. 3 sections. Start reading. A document may be served on a company or an officer thereof by sending it to the company or the officer at the registered office of the company by the registered post or by the speed post or by a courier service or by leaving it at its registered office or by means of such electronic or other mode as may be prescribed. Everyone please read. Completed up to here. Next, second one, provided that where securities are held with the depository, records of the beneficial ownership may be served by such depository on the company by means of electronic or other mode, save as provided in this act, or the rules made thereunder for filing of documents with the registrar in electronic mode. A document may be served on registrar or any member by sending it to him by post or by registered post or by speed post or by courier or by delivering at his office or address or by such electronic or other mode as may be prescribed, provided that a member may request for delivery of any document through a particular mode for which he shall pay such fees as may be determined by the company in its annual general meeting. That's all. Leave off. Explanation not required, sir, for that. Read subsection 1, proviso 2 and its proviso. Everyone in the class, please wake up. Please read properly. Important. Read section number 20, everyone, please. Completed reading? Tell me now, what you understood? So tell me what you understood from this? Huh? Okay. So, yes, who is that? Sorry. Sir, what is this particular concept now? And answer is also correct. With regard to this, let us understand the meaning first. Service of documents. A document may be served on a company or an officer thereof by sending it to the company or the officer at the registered office of the company by registered post or by a speed post or by a courier or by leaving it at its registered office or by means of such electronic or other mode as may be prescribed. Provided that where the securities are held with a depository, the records of the beneficial ownership may be served by such a depository on the company by means of electronic or other mode. This is the thing they want to convey. Sorry. Let us first understand the intent of section number 20. Point number 20, subsection number 1. Later we can read section number 20, subsection number 2. 20, subsection number 1 says that whenever anyone want to communicate with the company or to the officer of company, say for example, simplicity sake, ROC want to send a notice on the company. Repetition once again. ROC want to send a notice. Everyone repeat. What ROC want to send a notice? On a company. Or one of the officer of a company has done, like a director. Officer is a director. Any director has done some offense, financial offense. ROC want to send a notice to him. Clear everyone? I have given you two situations now. ROC want to communicate with the company. ROC want to communicate with the officer of the company. A company is not filing the returns properly. I want to send a notice to company. One of the director of the company has done some fraud in the company. I want to send notice only to him. Now there is one notice or two types of notices, sir. Answer. Now tell me, first notice will be sent to whom? Company has an address or not? What is the address of company? Registered office. So send to whom? Registered office. Second situation, I am communicating with the company. I am communicating with the director. Now I will send to the registered officer. Yes. That's what he want to tell. Sir, director will have an address now, sir? No. Listen please. I am communicating with him in his personal capacity, in capacity as a director of company. That also should be submitted only to the company. That also should go to the registered office of the company. Therefore, anyone want to communicate with the company or with the officer of the company, in such case, don't send to any other place other than registered office. Sir, I want to communicate with director. Sir, director address I know, sir. But should go to registered office only because you are sending the notices in his personal capacity, in capacity as a director of company. Therefore, it should reach company only. These type of questions they will ask in exam. Clear or not everyone in the class? Like how they will ask, ROC want to submit one copy of the document to the company, another copy of the document to the director at his address. You cannot. Even if you want to serve notice on a director of a company, you should send it only to the registered office. I repeat one last time, after that if I ask questions, I should not listen to the wrong answers. Point number 1. Someone or a department, GST commissioners, income tax commissioners, or ROCs under Companies Act, RD under Companies Act, any other departmental authority want to send some notice to the company. Where to send? Come from the beginning again. Any of the departmental authorities want to communicate with the company. Where to send the document? I don't want to communicate with the company. I want to communicate to the director of a company in his director capacity. Serve it only on the registered office. Up to here, everyone understood? Huh? That's the first point he want to tell. If you see there, second subsection la ROCN member is covered, not the officer. You are very, very bad in observation. Most of the students in the class, very bad in observation. Too much bad. If that observation is so bad, and never we will win the court cases, first point. Lifelong we will work under someone. Observe the words properly. I gave you chance. I am not directly asking any answer, and I will not expect like that. 5 minutes to 6 minutes you will take the chance and give wrong answers. So the point is very clear. Listen carefully once again. Whenever documents has to be served on a company or the officers of company, send only to the IPN. Game over. Don't send to his personal address, because you are not sending to him in personal capacity. You are sending to him in which capacity? Director of a company capacity. Therefore send to the company. Clear everyone? This is number one. Over. Modes of sending we will discuss it later. Now come directly to second subsection. Second subsection. Read from the second line onwards. A document may be served on the registrar or on any member. Now listen carefully. Company want to communicate with ROC now. Company want? Everyone. Company want to? Everyone. Company want to? Very good. Where to send is the question. Where to send? I will ask you one question. Answer this. I want to incorporate a company. ROC only will incorporate the company or not? Tell me, what is the document we need to take to incorporate a company? At least 10-15 times I told you. Okay? Really, if you don't remember this point, after class, directly go to a neurosurgeon. Something is going wrong in your mind. So, tell me, point number one, some chip might have lost 10 times minimum. 10 is minimum. Remaining I didn't count. The model of incorporation I told you so many times in the class, literally so many times. Tell me, what is the document we need to take? You will fill all the forms, attach MOA, attach other documents and file it with whom? In which website? Through which website you will go? Yes, depending on the state from which that file come, ROC jurisdiction will be decided by the back office. If I file from Hyderabad, they will take it as a state of Andhra Pradesh. So, from that it will be transferred, and from there it will get transpassed and it will go to the ROC of that particular state. Clear? Hyderabad, one ROC will be there. That particular person will take the control. Clear? State, all these things is a headache of the back office. There is a separate back office for MCA. The back office will look after that. Clear? Front office will take the administrative work. Back office will take this routing of documents. From which area a particular file has come to, which ROC jurisdiction it has to go. All these things is headache of the back office in MCA. They will look after that. Your duty is to file. You file it. Listening everyone? You will file through which website? MCA website you will file. Clear everyone? Then where is the question of again telling how to file documents with ROC? Did you understand my point clearly? Where is the question of filing with ROC? Through MCA website you have to file. Answer over. Tell me, spice form, print out. AOA, MOA, print out. Agile, print out. Documents, print out. Proof of address, proof of identity, print out. This much booklet has been made. I took all the papers to ROC office physically. At the office of ROC I went. I put the bunch of papers on his table. And I said that, sir, please incorporate. He will throw the papers and throw me also along with them. Both he will do simultaneously. Because two hands are there, bouncers are there. They will throw both, papers and me. Both will come out at the same time. Now you should understand the point properly. Why we will go physically and we will file? At the office, see here what he said. By sending him by post, we will send to ROC by post. And love letter. Did you understand the point or not? So how can you send by post? ROC with love and affection from Kaushik Mukesh, chartered accountant. So please take this file. Hmm? Like that we will not do. Are you understanding or not? ROC, please file this. Like that we will not ask him. So post, how post is possible? Registered post, secret letter. Speed post. Next, courier. It is the twist. Delivery at his office. Directly go to ROC and tell, ROC, take my form. So, which fool will do like this? Sorry, Act has said this. But practically, is it possible? Yes. That's why use the word save as provided in this act and rules made thereunder for the filing of documents with registrar in electronic mode. This will apply. If there is any section which tells a different way of filing to the ROC, follow that. If there is nothing said in the section, then section number 20, subsection number 2 will apply. Incorporation already has a procedure or not? Follow that. Don't come to this section. Now did you understand the point? That's why what is the start like? If person sitting in West Mambalame is getting doubt, means lawmaker will not get this doubt. Person sitting in West Mambalam in Chennai, we only got the doubt. How is it possible? Will we communicate physically with ROC? We sitting here, we get the doubt means they are the makers of the law. They don't get the doubt. Is it practically possible? It is possible. What they want to tell is, listen, I will give you quite good examples. There is a concept called as a charge filing. Charge means security. Asset is then loan taken. For this loan, assets of the company will be kept as a security. That's called as a charge. That's called as a, whenever you create a charge, you have to file CHG9. What is the form? CHG9 with ROC. That's a rule. Remember this. When we come to the chapter, we'll discuss at the remaining part. We have to file CHG9 form with the ROC. This is the general rule prepared by the law. Clear? How to file CHG9? Everything has already been given in the act itself. In the rules, they have given the procedure. How to, listening? Therefore, this question does not arise. That means, if there is a section which says how to file documents with ROC already through MCA, come to 20 subsection 2, don't come to section 22, don't come to section 22, this will not apply. Next example. ROC sent a notice to the company. ROC sent a notice to the company. ROC sent a notice to the company that there are some wrongs in the books of accounts of this company. Give me explanation. There is no form to give explanations through MCA website. Then this will get applied. Are you understanding or not? Who issued a notice? Issued a notice on what? Issued a notice on whom? Company. About what? Errors or mistakes in the books of accounts. He is asking for what? Explanation. Now understood? For this there is no form. CHG9, INC 32, spice like that. There is no form here. If there is a form, file through MCA. Form A not there. What to do? Normal communication you have to make. At that time, 22 will get applied. Everyone understood the point or not? Don't commit mistakes. Seriously, I am telling you, if I have to ask the question, I will ask like this only. I will create a case. Mr. A want to file a charge documents with the MCA. At that time, he came to know from his friend who is a chartered accountant that you can file even by post. Comment on the validity of the statement. Like that I will ask. No one who don't read the law should not pass the exam. Write again. Write again till you pass. Write again till you read properly. Write again till you read every section. Come again. CM is come again. Kada? It is certainly achievable if you read. So you write again, write again, write again, write again. Till you understand every concept, you write again. So the point is, listen carefully. section number 20 subsection 2, when it gets applied, when filing with the ROC is not predetermined anywhere in the law. For example, incorporation INC 32 already there, I mean SPICE, shortly called. For charge, CHG 9 is there. For declaration of commencement of business, yesterday only I told you, okay, that is there. Verification of register of INC 22A, these are all predetermined forms are already there in the website of the MCA or not? Yes, that means that form should be filed only through the MCA website with a electronic mode. You will file. Whose headache is to transfer the document to the respective ROC? Back office of MCA will look after. That's not your duty. If there is a document which is not governed anywhere in the act, I mean by MCA, in such case, how to communicate? A question will arise or not? The company can communicate with the ROC where? Now, I want every one of you to read section number 22, start. Save as provided in this act or rules made thereunder for filing of documents with the registrar in electronic mode. Continue. A document may be served on registrar or on any member by sending it to him. To whom? ROC or a member. Continue. By post, registered post, speed post, courier, or delivering at his office is called as what? Hand delivery. Directly go and give him. Directly go to the office and give him. Directly go to the member and give him. That's called as a hand delivery. Zomato order type. Zomato, all these are called as a hand delivery systems. Hand delivery means directly the person will come and give it to you and he will go. That's called as a hand delivery. So, delivering at its office or address or by such electronic mode. This is the point. Okay. Now answer my question. Company want to communicate with ROC. How to communicate? Company want to communicate with ROC. How to communicate? First, through the act you have to go. Save as otherwise provided in this act. If there is any other mode specified, follow that one or section 22. Follow that procedure. If nothing is said, 22. Tell me. I want to communicate with ROC. What are the various modes available? I have to communicate to whom? To him directly. How? Listen. ROC. I will ask a question. Read and give me an answer. Now I will see how much reading ability is there. ROC is a person who is having two addresses. One is an office address, one is a residential address. Where to send to ROC? Read and tell. Don't do overaction. Read. Take a minute time, no problem. But read and give a correct answer. Okay. Now tell me. Where to post, hand delivery, registered post, speed post, courier, electronic means understood. Modes are easy. Where? Place. Office or residential address are both are. How dare you can send the notice to the ROC house here? How dare you are? How dare you send the notice to the ROC at a house address? Will you live after giving notice? Really, will you live after giving a communication directly to ROC? Are you know who is ROC except his full form? ROC is having the powers of the High Court. He is like a moving court. He has the powers of civil court. You will give notice directly to the House of Civil Court. How gutsy you are. Please don't practice. If you practice a C, in a second day you will go inside. Hey, how can you answer? Where you send means I will send to the address of registered office. How dare you can say that? By common sense also it will not permit. Sir, he said here, sir, delivering at his office or address. Listen here. Hey, listen. Office is for ROC, address is for member. How beautifully you are reading, lawyer. Read again. You are taking this as a compliment. Read. Shall we continue? Okay. Now listen. When I tell registrar address, in capacity as a registrar, you have to see that. Not in his personal capacity. Are you understanding or not? When I tell registered address or registrar address, in capacity as a registrar, where he resides, that address you have to take. Clear, everyone? So therefore, this is the point. Now summarize everything and tell me, ROC want to ROC want to communicate with the company. Tell me how he can communicate. What is the modes available? ROC want to communicate with company or with the officer of a company. First tell me, send to the address of that person, send to the register officer. Perfect. Okay, what are the modes available? Registered post, speed post, courier, hand delivery, or electronic means. Tell me what are the sources available. Number one. One second. Do I give any exception proviso to any student in the class that you need not answer? Then don't do overaction. Everyone answer. First one, point number one. Registered post, speed post, courier, hand delivery, electronic means. Reverse case. Company want to give a notice to the ROC other than the filing through MCA website. Tell me now. I can give by a post, registered post, speed post, courier, hand delivery, electronic means. There I have to send to which place? First case, registered office. Here you have to send to which place? Office or address. That's all. This is what he want to convey. Everyone understood the point clearly, yeah? But one small point is, read the second proviso to subsection 2. Subsection 1 proviso don't read, because the depository, I will tell you, share capital chapter. Read the remaining content. Provided that a member may request for a delivery of any document through a particular mode for which he shall pay such fees as may be determined by the company in its annual general meeting. For example, company generally give notice to the members in the form of electronic means, email. One of the members said that, sir, I don't have access to my emails every single time. You do one thing, sir, please give as a courier or as a post to me. That means, email means no cost. But courier means we have to send it to your home or not. And moreover, general meeting notice means it will be like a book. It will cost us around 300-400 rupees. Therefore, who has to bear that? Member has to bear it. So therefore, if you ask any mode other than the mode I specified, for example, company generally gives through email. You are asking a specified mode, for that you pay the cost. I will decide in the annual general meeting. Clear, everyone? Who can request? Member can request it. Clear, everyone? Done. So this is the point you want to convey. So now we completed another section called as section number 20. 20 is also completed. Last two sections are there for us, 10 minutes each. Please see what is the 21st section, everyone. Authentication of documents, proceedings and contract. More complicated ones are 21 and 22. Let us see what they are. Please, everyone, start reading. Save as otherwise provided in this act, a document or proceeding requiring authentication by company or contracts made by or on behalf of a company may be signed by the KMP or an officer or employee of the company duly authorized by the board in its behalf. Read this first. Read the section. Save as otherwise provided in this act, a document or proceeding requiring authentication by company or contracts made by or on behalf of company may be signed by any KMP or officer or employee of the company duly authorized by the board in this behalf. Okay? Now listen carefully. What is this concept all about? This is talking about the principal agency. See here, company is a principal, board of directors will be the agents of the principal. Whatever the company can do can be done by who on behalf of company? Board of directors. Everyone in the class, please listen carefully. Important. Company is a principal, board is the agent. Since company is an artificial persona, natural persona, it cannot do anything on its own. Who has to do? Board of directors has to do on behalf of the company. Therefore, a question has started. Company has to sign on a document. Company's signature is required, but company can really come and sign. Then on behalf of company, who should sign that document? Question number 1. Second one. Company has a capacity to sue others or not? That's called as a proceeding. Company want to file a civil case against another person. Therefore, company is a complainant. Who has to sign? Company. But company is an artificial persona, natural persona. Can sign, cannot sign. On behalf of company, who should sign is a second question. Clear, everyone? Read the logic clearly. First, there is a everyone, there is a or there is a requiring authentication means what? Signing. By whom? Company. Company is artificial persona, natural persona. Can sign, cannot sign. Same thing like that. What is the next one? Contracts made by the company or on behalf of a company. So tell me, contract requires a written signature or not? Yes, answer. Yes, who will sign? Company is an artificial person. How company can come and sign? Therefore, in 3 cases. Number 1, document. Number 2, proceeding. Number 3, contracts. Everyone tell me. D, P, C. Tell me, what is the D? P, C. These 3 things are entered by whom? Therefore, who should sign? But company is a. Therefore, on behalf of company, who should sign? Is the question now. See there, who are having the power? May be signed by, start, KMP. What is KMP? Key managerial personnel. Okay. Or an officer or employee of the company duly authorized by the board in this behalf. Means either KMP has to sign. Sir, who is a KMP? Question will arise or not? Write down there, I will tell you the list of KMPs. In audit also it will come. 1 or 2 situations it will come. So KMP, write the list of KMPs. Managing Director, Whole-Time Director, Manager, CEO, CFO, CS. These 6 are called as KMPs. Please give the list. Managing Director, Whole-Time Director, Manager, CEO, CFO, CS. Everyone will be called as key managerial person. In a simple way, you can understand this way. Okay? Okay, now. So, may be signed by KMP, or any officer or employee can sign only if they are authorized by the board in this behalf. That means, tell me, document proceeding contract want to be signed by any of the, say for example, a director of the company want to sign on behalf of the company. Possible or not possible? Possible or not possible? Not possible, because he is not coming into the category of KMP. However, it is possible for a director because he is coming under officer. That means he is not a KMP, but he is a officer. So director can sign or cannot sign? Can sign. Not as a KMP, but as a officer. If I am a managing director, I am both officer as well as KMP. In any capacity I can sign. Clear everyone in the class? So summarize everything and tell me. 3 things are governed by section 21. Number 1, document, proceeding, contract. Requires whose signature? But requires KMP signature. Requires whose signature? Company. But company can sign or cannot? Therefore, who will sign? KMP or officer or employee. First listen, KMP directly can sign. Officer or employee can sign only if they are duly authorized by the board in this behalf. They can only sign on that particular document. Everyone understood the point clearly? Yeah. Now the question will arise. So this is a general topic. Documents, proceedings, contracts. Whenever are there, company can't sign. Sir, company cannot sign, therefore these people are signing. Then why he has to use the word company anyway? Directly he can use the name, can be signed by KMP, like that he can tell. Listen carefully. 1 second, sir. Will you please listen? Whenever you see the reports given to the company, audit report, board report, anything you see, they will clearly write for and on behalf of XYZ Limited, like that they will write. Means this we are not signing in my personal capacity. I am signing as a director of XYZ Limited, like that they will write. That means I am not signing in my personal capacity. I am signing in capacity as a director of that company. On behalf of that company I am signing. Clear? Always it's only an agent. I am an agent to the company, saying that they will sign. KMP, employee, officer, anyone can sign. Clear everyone? So documents, proceedings and contracts on behalf of company can be signed by 3 persons. Number 1, KMP, officer or employee, duly authorized by the board. There are so many officers and employees. Which person? Board has to authorize. Okay, you have a power to sign on document, you have a power to sign on contract, you have a power to sign on proceedings, like that it has to give the power. Clear? Done. This is the end of another section. Section number 21. 21 also over. Sir, everyone tell me 20, 21. Understood? Yes, let me summarize. I will ask you questions, answer. Fatafat. Point number 1. Tell me. I want to ROC want to communicate with the company. ROC want to communicate with the company. Where to send? No mistakes. Where to send? What are the 5 modes available? Registered post, speed post, courier, hand delivery, electronic means. Electronic means. Done. Over. Next, company want to communicate with the ROC. What are the modes available? post, registered post, speed post, courier, hand delivery, electronic means. Where to send? ROC na office, member any address. Done, over. Very good. Next, can a member request a particular place to send? That means I don't want that place, I want a different place. Can a member request or not? Cannot. Mode only he can request, not the place. Like this I will ask question if I have to ask. If I were to give a chance one time if I were given a chance, real I will show how good you can ask a question. I am not asking about mode, I am asking about the place. Place you can't request. What you can request? Mode only you can request, not the place. Okay, so that's the point. Next, DPC means what? Proceedings and contract, which require authentication of company, must be made only by whom? KMP officers or employees duly authorized by the board. Done. 21 also over. Last section, sir, let us complete this. Execution of bills of exchange, etc. Etc. means rule of ageism generis will apply. Maybe bills of exchange, any other negotiable instrument. Please read. Maybe to some extent you may feel complicated. Read. A bill of exchange, hundi or promissory note shall be deemed to have been made, accepted, drawn or endorsed on behalf of a company if made, accepted, drawn or endorsed in the name of or on behalf of or on account of the company or by any person acting under its authority, expressed or implied. A company may, by writing under its common seal, if any, authorize any person, either generally or in respect of any of the specified matters, as its attorney, to execute other deeds on its behalf in any place, either in or outside India, provided that in case a company does not have a common seal, the authorization under this subsection shall be made by two directors or by a director and the company secretary, wherever the company has appointed a company secretary. A deed signed by such an attorney on behalf of company and under his seal shall bind the company. Not even 1% is understandable. I know. Please read. Take a minute time. Read it properly. Hardly it will take 5 minutes to complete, but please read. Please read the section, everyone. Okay, completed. Hello everyone. Completed, ah? Tell me, what is the intent of the section? Yes, 1 second. Let one person answer. Next, what could be the need for the section? Company cannot do things on its own. Next. Sir, okay. All these explanations are okay. First point number 1, which you didn't observe, which you should have been observed. Shall I tell you? Huh? Shall I tell? See here. First point number 1. Subsection number 1 is talking about negotiable instrument, 2 is talking about deeds. I've been game over. First one, second one, no relation to each other. Second point, game over. See the point clearly there. I ask you to read. It's some observation. Negotiable instruments of a financial nature must be signed by any person in the company who is having an authority, expressed or implied authority. Second case law, only that person who has given attorney authority has to sign. Read again. Yeah. I will tell everything. Lastly, you come and tell, yeah. There is a Telugu movie. Okay, interview room will be there. That's original Dhanush movie. That's the first it was made in Tamil by the same director, C. Raghava. So first made in Tamil with Venkatesh. Telugu in Venkatesh. Fantastic, he played that. The same scene, first scene like interview will be there. Na? Everyone will tell something in English. Lastly, Venkatesh will tell, yeah. What he said, yeah. Like that, I will tell everything. Lastly, everyone tell, yeah. So tell me, point number 1, first subsection. Hey, listen here. Subsection number 1. Will you listen? Yeah. Subsection number 1 will be discussing about the negotiable instrument. Subsection 2 is discussing about the deeds. Listen, what is the difference between a negotiable instrument and a deed? Listen please. Document, proceeding, contract already we completed. Sir, then bill of exchange is not a document proceeding, sir. No, bill of exchange is not a document. It's a negotiable instrument. Over. Sir, then deeds are not documents, sir. Deed is different, document is different. Deed contains terms and conditions. Document can contain anything. So, DPC governed by section 21. Deeds and negotiable instruments are governed by 22. Listen carefully. 22 subsection 1 covers negotiable instruments. Whenever check has to be issued by company is an artificial person or natural person? You are not listening. Company is an artificial person, natural person? Can companies sign on negotiable instrument directly? Who should sign? Who should sign? Any person having authority, expressed or implied, example directors. I told you very clearly 179 subsection number 1. Whatever the company has to do, it can be done by whom? Those are the people who are having implied authority. Who? Tell me. Whatever principal can do, that can be done by? Everyone repeat. Whatever principal can do, that can be done by? Who is the agent to company? That's all. Any of the board of director can sign. If I clearly say only Mr. A in the board has to sign, that becomes express authority, only he has to sign. If I don't tell anything, any of the director can sign on the negotiable instruments like bills of exchange, hundis, promissory notes, etc. Everyone understood the point clearly or not? Repeat for one last time. Bill of exchange, hundis, promissory notes, negotiable instruments shall be signed by company. Company can sign or cannot? On behalf of company, who can sign? Any authority having express or implied powers. Express means what? Clearly I said you have to sign. Implied means what? I didn't tell anything. Any director can sign. Clear? Huh? In case of deeds, implied authority will work or will not work? Because in case of deeds, company may, by writing under its common seal, means common seal will be there for company or not? Optional or mandatory? If common seal is there, right, who can sign on the deeds? Your attorney. Attorney means agent. Attorney means what? Agent. Who can sign on the deeds on behalf of company, write in this particular document and give a common seal. If you give a common seal, as its attorney, that attorney only can sign. Sir, my company don't even have a common seal, sir. Then how can I write and paste a common seal on that? I can't affix a common seal. Then what to do? Then who is the attorney should be selected by two directors. If company is having company secretary, one director and one company secretary has to decide. I will give you 1 minute time. Read subsection 2 and proviso. I should not hear wrong answers. Clear? See there. A company may, by writing under its common seal, if any, authorize any person either generally or in respect of specified matters as its attorney. Means, if common seal is there, take a stamp paper. Kaushik Mukesh, a director of the company, is having a right to sign on any deeds on behalf of company. If you write now, only Kaushik Mukesh will have the right. Because who decided that? Common seal, they have decided. They written and they affixed the common seal. Clear? Common seal means company is authorizing it. Common seal is not there for my company. In that case, that same written agreement should be signed by whom is the question now. Who should appoint? Two directors will appoint one attorney. That is one option available. If there is a company secretary, a director and the company secretary both put together has to appoint one attorney. So listen carefully. Authorization under this section shall be made. Authorization under this section. Which authorization? Authorization to appoint attorney. Who should be the attorney will be decided by whom? Generally, two situations. Attorney will be decided by common seal. If common seal not there, two directors. If company secretary is there, one director and that company secretary has to decide who should be the attorney. Sir, don't make mistake. Two directors will not sign on the deed. Director and company secretary will not sign the deed. Director and company secretary will authorize attorney. Or if company secretary is not there, two directors will authorize a attorney. So summarize everything and tell me, bills of exchange and negotiable instruments must be signed by whom? Any person having authority. Which authority? Express or implied. Done. Deeds can be signed by any person having implied authority. No, it should be signed only by the specified attorney. How the specified attorney will be specified? Either by common seal. If common seal is not there, Two directors will authorize one attorney, or director and company secretary will authorize one attorney. Everyone understood? Huh? With this, section 22 is also completed, and successfully we have completed the first chapter, the important one, incorporation and incidental matters. The chapter has been completed. The biggest, second biggest one in the syllabus is completed. First biggest will be the prospectus and share capital. Second will be the, third one will be the management and administration. One biggest one is completed. Next, tomorrow's session, full day session is there. We can effectively start directly with the prospectus and share capital chapter. They are two different chapters in the study material, but we don't read like that. All the 50 sections of prospectus and share capital, we read as a one set of chapter. We merge both of them and read. Such that 20 marks the set will be over. Hope you are clear, everyone in the class. So, in the next session, we are going to start with a new chapter, very interesting, very practical, stock market related. The chapter name is prospectus and share capital. Pin by pin, point to point. Like, 1 second. There are so many concepts like buyback. What is the concept? Buyback, rights shares, bonus shares, reduction of capital, diminution of capital, consolidation of capital. What is the difference between the stock and the shares? Every single point, merging the stock market with it, merging the financial management with it, merging the concepts of financial management. Every single point we will explain in such a beautiful way that will become memorable for life. Prospectus and share capital. So many practical issues will come. Say for example, we generally see buyback concept. Buyback means company will buy its own shares. But why it buy? What is capital redemption reserve? Each and every point in detail we are going to analyze in that particular chapter, prospectus and share capital. Clear everyone in the class? So next session we are going to start with that. Okay. So next session, don't miss the introduction to the chapter, because we are going to start with prospectus, share capital, combined introduction will be there. Clear everyone? So thank you.